everyone, welcome to another edition of Take a Minute Thursday. It's Karen Roberts from the Emerald Financial Group, and I am joined today by Nicole Loughlin of Loughlin Law PA. Hopefully you've been watching the last couple of weeks as Nicole has walked us through what are estate planning documents, why do we need them, guardianship. If you don't know what I'm talking about, that means you haven't been paying attention. If you want to catch the old videos, they're all housed on our website at emerald-financialgroup.com underneath videos. So today Nicole is going to wrap it up with, oh my gosh, you're dead, now what? So on that cheery note, Nicole, take it away.
Thanks, Karen. Yes, I'm Nicole Loughlin, Loughlin Law PA. I'm an estate planning and probate attorney in Boca Raton, Florida, and we handle estate planning and probate throughout the state of Florida. So you're dead, now what? That's the topic for today, and we're basically going to go over the probate process, a very simplified overview of what the probate process is and what your loved ones need to do after you die to get things moving, whether you had a will or you didn't have a will, or whether you had a trust. So in the event that you have a will, your loved ones are going to get a copy of your death certificate and take the original will and an original death certificate and deposit it with the court. And that needs to be done within 10 days after you pass away. The will needs to be deposited with the court within 10 days. If you don't have a will, your personal representative is going to be determined based on the Florida statutes. So if you recall from the last video, the personal representative is the person either you've nominated in the will, or if it's by statute, it's the person who is going to be in charge of administering your estate. So this person is a fiduciary who's going to petition the court, gather up all the assets, identify all of the creditors, put the creditors on notice, and make distributions according to your wishes or according to the Florida statutes. And when I say that, what I mean is if you don't have a will, the state of Florida will write one for you. It's very statutory. So during your lifetime, while you're able to and you have the power to do your planning, get it all down in writing so that somebody else isn't making these decisions for you later on. I've seen it happen where people are in second or third marriages, they have adult children, they have a spouse who they're going to go off into the sunset with, and they die without a will, and it can be very messy and complicated during that probate. You have adult children and second or third spouse, and everybody is not getting along. It doesn't matter, Karen, if there's $10,000 or $10 million, when emotions and grief and, people who aren't getting along,
Right.
It makes for a messy probate.
Yep.
So
we see it all the time. We see the kids try and throw out the second and third wives from the house because they think it belongs to them. They didn't like the wife, so please get it taken care of while you're alive.
Absolutely. So during the probate process, why we want to avoid probate is because probate typically is at least 12 months if it's a formal administration. So it's a lengthy process. And it's costly. It's around 3%. If your assets up to $1 million in assets is 3%, and then it goes down a little bit if you're over $1 million and it's tiered. You'll end up paying between 2 and 3% to attorneys and your personal representative, so up to 6% total to administer your estate. Some little nuanced items with probate: if you have homestead on your home, if your loved one died in the state of Florida and they lived in their house or their condo, that particular asset is dealt with differently in probate court. And a lot of times people will come to me and say, all my mother had was her condo in Florida. We just want to sell it. She died last week. Okay, we cannot sell a condo within a week if it's homestead in the state of Florida. Very likely, if there are creditors, we're going to have to wait out a 3-month creditor period. Wow. Most estates have creditors or have potential creditors, And so the safest way to deal with creditors is to publish a notice to creditors, wait 3 months, and then start to distribute the assets, including getting an order from the court to either sell the home or an order determining homestead on the home. So that's the way probate typically works. Once you pass the creditor period and you determine who is owed money and what order or the priority in which those claims will be paid, then you can get down to distributions. And if you had a will and you're going through probate, the distributions will be in accordance with the will. If you did not have a will, again, it's going to be in accordance with the Florida statutes. Now, if you had a trust and you had no assets that needed to go through probate, your loved ones will have some work to do still, but not as much work to do. They'll have to, the successor trustee is going to have to accept the position as successor trustee, and they're going to have to apply for an EIN and then take those documents to you, Karen, so that you can unlock the accounts and open them up for the trustee to start acting in accordance with the trust.
Right. So often our clients' beneficiaries come in and want the money or want to make changes to the account, and you can't do any of that without seeing Nicole first and then doing paperwork for us. So it's a somewhat lengthy process. Just because you step in doesn't mean, boom, the lights are turned on.
Right. And I'll say it's a much more streamlined process than if you have to go straight through probate, because the difference is you make an appointment with me and your trustee, we can get your documents out right away and they can take it over to you. But if you need a court order, that means we have to petition the court. We have to obtain waivers and consents from any and all beneficiaries in the trust or in the will, or whoever the statutory beneficiaries are. We have to file all that with the court and then hurry up and wait for the court to sign the order. Right. And depending on the jurisdiction, that can be relatively quickly, or it can take several weeks for that to happen. So it's much easier to get the ball rolling with a trust than it is with a testate or an intestate estate in probate court.
So the bottom line to all of this is plan for today, right? So that your beneficiaries and your heirs don't have to go through this nightmare tomorrow. It's going to cost you a little bit more today, but it's going to save them a whole lot more tomorrow.
Absolutely.
So perfect. Thank you so much, Nicole. This was awesome. I hope you guys learned so much about your estate documents. If they're not up to date, please feel free to reach out to myself or Nicole, and we will make sure they get up to date. If you're not sure if yours are still valid, still up to date, still what you want, bring them in. Let's review them. I'll review them. Nicole can review them, and we can tell you whether you need to make changes or not. But please, please, please do not procrastinate about your estate planning needs. So thank you so much, Nicole. We really appreciated you being part of Take a Minute Thursday. This is Karen Roberts from the Emerald Financial Group signing off. See you next week.
Thanks, Karen. Thanks, guys.